Okay, listen, I still got Gene Rossi with us. Gene, that last story is just compelling because it brings us to a space where any one of us could be, a lot of these crimes get committed, and a lot of times I would never be in that circumstance. It really drives home. There you are in Walmart, and some maniac comes in with a gun. What do you think about this?
Well, it's everybody's worst nightmare, and I'm wondering if the person was addicted to drugs, painkillers, because I see he's shooting into something. They said they don't know what the motive was. I bet you the motive was he's trying to get money to support a drug habit or some kind of addiction.
And actually, I'm not sure if it's shown on this tape or not, but it's kind of like a harrowing thing at one point in time. He's like trying to get into cars and carjack people, and at one point he shoots through a window, and I believe he hits a young man on the hand with one of the bullets. I mean, you should imagine somebody coming at you in your car with a gun and shooting and firing in there. I look at it as, it could be drugs, probably a combination of that mental health problem.
He looked like he was a little bit deranged. I have a dear friend. He was a former federal prosecutor. He had to leave the Justice Department. He was hopelessly addicted, and he ended up robbing 5 federally insured banks and 2 stores. He served 7 years in jail. He's now out, and he's one of my dear friends. He was a Marine. So it can be very powerful motive.
Yeah, I had this similar situation. One of the police officers I had to unfortunately prosecute got addicted to painkillers from a back injury, and then when the doctor cut him off, wound up breaking into the evidence locker and taking the opioids and heroin out, and obviously that's not a good thing, and he went to jail for that. But it is really sad, and I always say too, Gene, you got to tell people, my wife thinks I'm a little kooky about this, but you got to be prepared. You got to have your wits about you. You got to know what's going on around you should anything happen, and I think cops and law people are more tuned to that than the average citizen.
Oh, absolutely. Because I was a former prosecutor, whenever I go anywhere, especially where there's a lot of people, I was at a Friday night football game last weekend with my son, and my son's team beat the other team, and after the game, I was waiting for a gunshot or a fight. It was because high school kids, when they get out of control, it's pretty amazing. It's pretty amazing.
Yeah, well, great commentary. I appreciate it, Gene. Hey, guys, we're in the Van Dyke trial here, and Jason Van Dyke is on the stand. We've been breaking it down since 12 o'clock with Gene Rossi, and we're going to come back after we listen to a little bit more testimony and give you a little bit more insight as to why we feel the jury came back with the verdict of guilty second-degree murder. Okay, well, that's Jason Van Dyke testifying. Gene Rossi. I mean, we've listened to a lot of clips here. Honestly, we're passionate about this and talk about Zen and all that. But, the more I keep seeing this stuff over and over again, there's something that's just haunting me. It's disturbing to me. I don't know whether it's this guy's giving rehearsed testimony, if he's been told to say or not say certain things, if he wanted to take the witness stand or not. He's contradicting his witnesses. The prosecutor doesn't know how to ask a cross-examination question yet. He's not taking advantage of it. From the outset, I mean, do you think something wrong went on here? Like this guy is just making this up? Is he in a psychologically capable to get up there? Do the judges even ask whether you're on medication or you're psychologically infirm before you take the witness stand? I almost feel like this guy got sandbagged here by taking the stand.
Bob, I got to tell you this. This is why I love juries. The right to confront, to see the person on the stand. He looks like a person who has given up. He looked like a man who feels he's guilty. The answers he gave were incredibly tentative and oh my goodness gracious.
Yeah, I mean, I agree with you, Gene. I mean, we've been around the block and we've cross-examined defendants, many of them. We've put some of our clients on the witness stand. There's just something in my brain that's telling me this is just a completely, like you said, he's given up. He's just going through the motions. He's contradicting his own defense. I think he's almost making stuff up to hurt himself.
Well, this is a bad answer. He didn't know that he didn't know the purpose of why he's talking to Dr. Miller, his own expert. Nobody's going to believe that answer. His attorneys probably told him why. That's not believable.
Yeah, I mean, let me ask you a question, because I've never confronted it before until I've seen a guy like this. What if later down the road it's determined that he was suffering from some psychological condition and really had no business getting up on that witness stand or wasn't able to make a competent decision. Have you ever witnessed something like that before?
Guess what? When he gets convicted and he exhausts all his appeals, you're going to see a petition for a writ of habeas corpus filed against his warden saying that his defense attorneys did not fully explain the pros and cons of taking the stand, and his defense attorneys did not prepare him for taking the stand. Got to tell you this, I can see that petition right now.
Well, you know, we've seen that kind of petition made before, Gene, and rarely, but on some instances it's successful. But I think guys like me and you that are looking at this, that do this every day of our lives, it's kind of like jumping out at you. It's somewhere down the line, somebody needs to ask these defense lawyers, how did it come about that this decision was made? Because it's just factually ludicrous to me based on what he's testifying to.
Well, the reason I love this show is we can get some education here. When a prisoner in state prison files a petition in federal court, the attorney-client privilege is washed away, so you have a battle between the defendant and his attorneys as to who, what, when, where, why, and what was said. It's a he said, she said. And he's going to say, my attorneys were terrible. They're going to say we were great. And that's what the hearing's about.
So talk to us about what goes on from here, Gene. I mean, there will be an appeal. Ineffective assistance of counsel will likely be part of it. Are you seeing anything jumping at you now before that would obviously occur prior to the habeas petition? Tell us the path, our viewers, the path to how opportunities he has.
Here's the opportunities. When he's convicted, he will have his sentencing. A final order will be issued, and then he'll appeal to the appellate courts of Illinois, and if he's unsuccessful, he'll appeal to the Supreme Court. If that is all zeros, goose eggs, he then can file a civil petition in federal court where the trial was held to say my interest for assistance of counsel was violated. I had a bad attorney, and you will have in federal court a hearing to determine whether the attorney's bad. I think that could happen.
Right, and I've actually, we had less than a minute, Gene. I've actually, in Jersey, you also have multiple opportunities for what they call post-conviction relief on the state level, where you can raise these arguments. In fact, this network has actually covered cases that have been reversed in a post-conviction relief application. The Villegas case that we just covered, or maybe on a habeas that comes back retried and the person's found not guilty.
Right. Bob, what I love about these petitions for writ of habeas corpus or alleging ineffective assistance of counsel is the prosecutor gets to work with the defense attorneys and get them to explain why they made certain decisions. I had 2 hearings of this nature where I had to talk to my opposing counsels. What did you tell the defendant? Because the attorney-client privilege is waived. Right.
Gene, listen, excellent commentary as always. There's something that's just a little bothersome to me about all this, and it's great to have you to break it down. We're going to go to a break. We're going to come back more on the Jason Van Dyke post-trial analysis. All right, that's Jason Van Dyke. Gene, we've been talking about this all day, and I'm coming to some iterations in my own mind as I see this over and over again. He obviously didn't help himself out, but as I've indicated to our audience before, and there is a tunnel vision that goes on when you shoot, and it doesn't necessarily mean when you thought you were backpedaling. Or I've said it before, cops many times in cases I've investigated don't even remember why they shot. And then in the end, you look at the MVRs and the body cam footage, and you come up with an explanation as to whether it's justified. We see it on the screen right now, Gene. Here's a point. I'm just playing devil's advocate now. He's walking away. Laquan, he's got that hand down by his waistband. Here comes the officer. And, to me, I'm surprised there wasn't more of a discussion, as you said before, about parsing out the violent encounter beforehand, not listening to officer commands, and what was going through his mind step by step, and that he may have had a gun on him. Thoughts?
Absolutely. The prosecutor made a big deal about these 6 seconds that he had all this time to make decisions. When you got a gun that you're holding towards somebody, 6 seconds is like 1/100th of a second. Things are moving fast. And I got to tell you, this is where the ineffective assistance of counsel could come in. I didn't get any sense that they went through every slide, every millisecond to show to the jury what was in his head when he made every decision involving each bullet? Why did he shoot the second bullet? Why did he shoot the fifth bullet? There was no explanation. There was no humanizing of your own client. It was, I got to say, this is painful to watch. It really is.
Yeah, and I know that made this, and again, we're not saying this for any reason other than as skilled trial attorneys that have been on both sides of the equation. You want there to be a fair fight on both sides, and ultimately a jury come to a conclusion. But what myself and my friend Gene Rossi are talking about is that there just seems to be such a disconnect between putting this defendant on the stand and not explaining the culture, what's going through his mind, what's going through his brain. And he is not necessarily a likable guy either, Gene. You noted before you thought that he had a problem with the female prosecutor in particular, but he is somewhat combative. But to me, he just looks completely confused.
But Bob, I just saw that the shot of him sitting at the table. Okay, he looks disheveled. His shoulders are slumped. He looks like a guy who gave up. He looks like my kids used to look on the bench going to basketball when their team's getting beaten by 20, 25 points. That's the way my kids used to look on the bench. They look defeated, and juries see that. They see that. Yeah,
that's true. It's probably the way the teams looked when you shot that 40 or 41-point game back in the day in high school, too.
Well, Bolton and Ram.
My man. All right, let's listen to some more Jason Van Dyke testimony. Gene, I don't know what to say. I think that your point is well taken, that he's just defeated and he's given up. I just want clean trials. I want people that are guilty of things to be held accountable, but not more than they should be. I don't like seeing lawyering mess things up. This was a terrible choice to put this defendant on the stand, and he sealed his fate. And who knows whether or not that testimony could have significantly changed the outcome of the case, especially when you're trying to one juror is all he needed to hang them, if you will, to have a mistrial. But how can any juror do that after this testimony?
Bob, if I'm sitting in that jury box, there's not one juror who likes Jason Van Dyke. And that's not a good place to be if you're a defendant.
Yeah. I don't know, Gene. In your state, let's look at when a defendant takes a stand. You can also put reputation evidence. These are all little ways that we try to build the credibility of our witness. The fact that he's a 15 or 20-year veteran, he's a father with 2 kids. I assume, I don't know this for certainty, maybe not a significant or any record of violence in the past. I mean, it's not like he just flipped a switch one day, and this would be my argument, right, and decided I'm going to go out and kill Laquan McDonald for no reason. He obviously felt he needed to. It may not have been the perfectly correct decision in hindsight, but it's the decision that he believed was reasonable at that time.
Bob, I haven't seen the whole trial, but I would have spent probably a third, if not 40% of my case describing his career before he pulled those 16 shots. What kind of man he was. What did he face in those 15, 20 years as a police officer? What commendations? The guy I just looked at testifying for the last hour and a half, that looked like a guy who was a rookie cop. I mean, this is a man who's experienced, and I didn't get that impression at all.
Yeah, and you know, I think that this goes to, you know, the ineffective assistance of counsel argument that you were raising, Gene. Again, we haven't all watched the entire thing, but the enormity of the decision, the terrible presentation of that, and the prosecutor, by the way, it's interesting to me, was making a lot of mistakes that they weren't picking up on. Like when she said, you're not supposed to shoot the knife out of his hand, but shoot center mass. That's the point. That's what I would have been saying as a defendant. That's the point. You neutralize him. There's no magic number of bullets. They don't teach you in the academy it's 3 bullets, 4.2 bullets, 7 bullets. He did fired a number of rounds in order to take him out and neutralize the threat. Now you're going to argue with him because he says he's shooting a knife out of the hand? I don't know. It's weird to me.
Exactly. And I just thought of this.
Give me 10 seconds, Gene. Give it to me.
Yeah, we don't know if there was something in his background administratively that could have been used on cross if they brought up he's a great cop. We don't know that.
That's an excellent point. You know, there's some things that you just don't have an opportunity to know. And if you brought out reputation evidence, that could have been used to cross-examine him well. Gene Rossi, that's why we love having you on. You know all the nuances and permutations. Hey, guys, we're going to go to a break, and we'll come back on the other end with more of the Jason Van Dyke case. Okay, welcome back. We are covering the Van Dyke trial. We've been listening to a lot of testimony of Van Dyke. Gene, it's great having a pro like you on. We're even talking about it offline. But I have one of our chatters in there asked sparked a question for me that I think is really important to talk to our viewers about. It essentially is, will he be put in segregation? Nellie asked this question. So walk us through what happens when he gets out of that courtroom, where he goes. As a police officer, he's at greater risk. Where will he be classified? What are your thoughts about what his jail sentence is going to look like whatever that number may be?
All right. Is it Nellie? She asked a great question. In Alexander, Virginia, we've had some high-profile defendants. Zacchaeus Moussaoui, Paul Manafort, Robert Hansen, the FBI agent who went rogue. What happens when you have someone like that in your jail? They're segregated. They have to sleep alone. They have to eat alone. They have to work out alone. And here's why, especially if it's a police officer convicted of second degree. The other prisoners may kill them. That's the bottom line. Jeffrey Dahmer was killed in prison. So Jason Van Dyke, when he gets to that Cook County jail, wherever jail he's going to go to, they're going to segregate him and protect him because prisoners will want to take his life.
Now, Gene, I agree with you completely. And, Gene, you know that when you're segregated, most prisoners will eventually get to a point like, take me out of segregation. I want to go into population. They need human contact. They want to build relationships, and they'll even put their own life on the line in order to get out of that segregation. Whether the jail does it or doesn't do it is another situation. But that lockdown is no joke. That's like 23 hours a day in a cell. Am I not right?
It's like you're on death row.
Right. So let me ask you a philosophical question, Gene. Very few people that I would ask this to, but I will you because of your experience level. What are your thoughts about the idea that if you were the judge and you're sentencing him, or if you're his lawyer representing him, saying something to the effect that any jail sentence given to a police officer convicted of these offenses will be far more excessively worse than it would be for an ordinary person? And, Judge, you have a lot of discretion. I believe it's anywhere from 6 years to 20 years, 20-plus years. I'd ask you to take into consideration that minute by minute, hour by hour, every day that he's got to be in that jail is like 5 times the time for any ordinary person. Is it a fair argument to treat defendants separately based on who they are?
Absolutely. That argument came up in a lot of my cases. I used to prosecute pain doctors, and 5 years for a pain doctor in prison is like 30 years for someone who's convicted of a violent crime. That is a very good argument. The only problem with making that argument for this judge is he's been convicted of 16 aggravated assaults. And by the way, under Illinois law, the maximum penalty for aggravated assault is higher than second-degree murder, believe it or not. So you have 16 counts plus a second-degree murder. Your argument has weight, but I think a judge is going to max them out. I really do. Wow.
Really amazing. Okay, Gene, thanks as always for the commentary. So, guys, you heard what Gene Rossi thinks. He thinks he's going to be maxed out, and like I said, he's going to be maxed out on some seriously rough time because he'll have to be segregated, in my opinion, for most of that. The officials aren't going to take a chance. That is really hard time. So let's go back and look at the man who is fighting for his life on the witness stand to try to not let that happen, Jason Van Dyke. Okay, back to my man, Gene Rossi. I know, Gene, you were having a little difficulty hearing it. There were 3 really short clips that were there. But again, I want to go to a point that we raised earlier for those who may have joined us that, he was not being cross-examined, Jason Van Dyke, by, with all due respect, Clarence Darrow, okay, if you will. A lot of open-ended questions. And what's shocking to me is that they're asking, the prosecutor asked, why did you shoot him? He's hesitating. He's asking, I'm sorry, what is it? I don't get it, Gene.
Well, first off, I'm going to call her Clarissa Darrow. But there were so many. Whenever you ask a defendant or any witness and you're cross-examining why, WHY, there are exceptions when you can do that. But in this case, the why, he should have hit it out of the park like Lou Gehrig and Babe Ruth. My goodness gracious. And his answers were just complete duds. It was painful. And it could go to preparation. It could go, and this is possible, Bob. You've had this, where you put a witness on the stand, you prep them 3 or 4 times, and they became Jekyll and Hyde, and they just lost their cool, like Colonel Nathan Jessup and A Few Good Men. They just lost it. He went the opposite. He didn't show any emotion.
Yeah, the only emotion he showed, and I'm curious as to you to amplify on this comment a little bit, is being surly with the prosecutor, calling him miss and ma'am, and really like directly at her. Why did you bring out that piece that she was a female prosecutor? What led you to that conclusion? Do you think the jury felt that way?
Wait a minute. You mean the female prosecutor was doing the cross-examination of him?
Right.
And well, what was your question, Bob?
Yeah, you had indicated earlier that you thought he had a problem with her because she was a female. What did you mean by that?
Well, I worked with a lot of police officers, and I worked with a lot of female prosecutors. And when I would ask questions in prep sessions with the police officers, who are guys, you know, we had the whole bonding thing, you know, we talk sports. But when the female prosecutor would ask a question, there'd be a little epiphany and like, who are you? And I could see that who are you attitude from Jason Van Dyke when the female prosecutor was asking certain questions. He couldn't control that. And I'll guarantee the jury saw that too. Yeah,
that's interesting analogy. Guys, listen, you are looking right now at a man convicted of second-degree murder. And if you look at that body language, like Gene was saying, he looks as if he's defeated. It's all over. He looks confused. His testimony was not good in front of the jury, either from a substantive point of view or from a likability point of view. And in my opinion, could have substantially altered the outcome of this case. So listen, we are going to go to a break. The Law&Crime Network, we handle this gavel-to-gavel post-trial analysis with Gene Rossi. We'll be right back. Welcome back to Law&Crime Network. We are doing a post-trial recap with Gene Rossi, my friend from Virginia, also known as hashtag 40/41 for all those great games that he shot when he was in high school. But Gene, I know you're getting ready. I told you I was going to do something. I told the producers I've been given permission. I'm starting a new segment on my show. You are the first test case. So are you ready? I know you don't know what's going on, but I know that you are a lawyer that knows how to respond at the drop of a hat to what's going on. It's my new show called Flip the Script. And Gene Rossi, I'm going to allow you to ask me a question. Me, the host, you, the guest. Now you, the host, to me, the guest. What's the question you want to ask me, Gene Rossi from Virginia?
Closing argument in the Jason Van Dyke trial, what would be the 2 or 3 major points you would say to the jury?
Well, that would depend if I was closing for the prosecution or the defense.
If you're defending Mr. Van Dyke.
Yeah, listen, I would like to be in a space to say, folks, these are split-second decisions. And a videotape, like anything in life, does not tell you the whole picture. We have a man with a 20-year career, whatever the number was, who's been a good, faithful police officer. He did not wake up that day and say, I am going to go out and shoot an unarmed person or a person with a knife. He did it because he felt he had to do it. A person who had previously been out and committing a robbery where he almost assaulted a person previous to that at the trucking yard. A person who was failing to listen to officer commands, walking down the middle of the street, who, by the way, was on PCP, looking a little crazed, not listening to the cops, holding a knife in the hands. And then this man goes and assaults the police car. Now, you may not think that's a big deal, but for somebody who's doing something like that and then punctures the tire, he's letting you know he's willing to use that knife against the police. So when Jason Van Dyke, 20-year veteran, comes out here never having been in charge or trouble for something like this. And that man spins around, has his hand by his waistband. He is in fear of his life. Now, well, you know what? 2020 is great. Being a second armchair quarterback is phenomenal as well. But you weren't the ones that were out there. You listened to what goes through his mind psychologically. This man shot him, unfortunate as it is, because he believed reasonably that he was in fear of his life or that man could escape and harm citizens. And unfortunately for him, he has an affirmative obligation, ladies and gentlemen of this jury, to protect the community, not to run away like the prosecutor would have you think. Something like that.
Whoa! That makes Columbus Day very special,
you know
Bob.
What, Gene?
You know what we should do?
Fanning myself now.
We should play what you just said and then compare it to what was actually said in closing by the defense attorney. That would be a beautiful show in itself.
Yeah, well, listen, hey, Gene, you were the first one on Flip the Script on my show. You did a great job. I knew you would be able to come back and ask a great question. And you know what? It is a good question. We were talking about this before, Gene. If you rely on those experts and you didn't get on the stand and contradict yourself, again, for whatever, people lie or misrecollect, or maybe he thinks he's got to answer a certain way, he's not properly prepared, whatever the explanation may be. Had he not taken the stand, Gene Rossi, I believe with a summation somewhat similar to that, and with the experts, you could have gotten that one juror at least to hang the case. Thoughts?
Absolutely. Jessica Chambers, hung jury. Mr. Liggins. It's possible to get a hung jury in horrific cases. It was possible that they could have gotten one juror to hold out. Absolutely.
But, you know, I think that we also have to talk a little bit here, Gene, is really important about jury psychology when they go into that room. Because that one or two jurors that may have hung, and maybe it was more for all we know, we'll probably never know the answer. They're almost defenseless in that jury room with those who want to convict because of his testimony. In other words, they don't have an ability to say, well, you listen to the expert, and it was the things that the Bianchi summed up to, or the defense lawyer summed up to, were really disproven by his testimony. He took away the arguments for those who may have been in his favor, and that has a big effect in that jury room.
Absolutely. When you go into that jury room, they try to apply the jury instructions to the facts that they see as judges of the facts, but they also have to not love or like the defendant, but they have to have empathy for the defendant and sympathy. And his testimony did not warrant any empathy or sympathy from the jury. It was very sad.
Yeah, quite the opposite. And in fact, if you were ever really to do a huge summation, I think to your point, if you had a lengthy opportunity, so right what we see right there, Gene, you pointed this out, is I would like to also be commenting about the idea that do you know the toll this has taken on this man and his family? Now, there's ways we can get that out there as a good lawyer. It may not necessarily be admissible everywhere, but you got to hit the sympathy factor.
Absolutely. Oh, God, I got to tell you, a petition for writ of habeas corpus based on ineffective is going to be filed as soon as they have the ability.
All right, listen, Gene Rossi, you are an amazing guest to have. You were my first one on Flip the Script, and you asked an excellent question, but you got me all like wet and on fire here on the Law&Crime Network. We're covering the Jason Van Dyke trial. This is an amazing case, guys. Whatever your point of view is one way or the other, I think me and Gene are bringing out, both the good, the bad, and the ugly about his testimony and whether it could have made a substantial difference. So please stay tuned. I'm going to be back with more Law&Crime and with Gene on the Van Dyke trial. Welcome back to Law&Crime Network. Unfortunately for me, my time is done. I'll be back Wednesday from 12 to 3. Carissa Kranz is going to be, from this point forward, taking you through this case. I want to thank my excellent guest, Gene Rossi. Gene, I always love having you on, my friend. Not only are you entertaining, not only are you a great lawyer and a great analyst, but you are also a great basketball player, apparently. I'll see you soon, Gene. Thanks for your time.
You're the best.
Goodbye to you all. We'll see you soon. Chris will be taking over next.